I'm sure many of you are familiar with Professor Richard Myers. He's a professor here at the Law School of Ave Maria. He is a Phi Beta Kappa graduate of Kenyon College. He has earned his law degree at Notre Dame, where he won the law school's highest academic prize. He began his legal career by clerking for Judge John F. Kilkenny of the United States Court of Appeals for the Ninth Circuit. Professor Myers is the co-editor of the St. Thomas Aquinas and the National Law Tradition, Contemporary Perspective, which was published in 2004 by Catholic University of American Press, and a co-editor of Encyclopedia of Catholic Social Thought, Social Science, and Social Policy, which was published in 2007 by Scarecrow Press. Professor Myers is the president of University Faculty for Life and executive secretary of the Society of Catholic Social Scientists. Professor Myers is married to Molly Murphy, who is a professor of law, also at the Ave Maria School of Law, and they are the proud parents of 6 children. Professor Myers wrote about my sister's case, and today he is going to speak and touch on the issue of why the withdrawal of food and hydration is bad law. Professor Myers.
It's a great pleasure to be involved in this gathering, and it's good that we have such a good turnout for this. As Bobby mentioned, I wrote an article about this several years ago that was published in the University Faculty for Life annual volume. I have maybe a few hundred copies of it. I'd be happy to get rid of, trying to clean up my office. So it's also available on the University Faculty for Life website, and I would encourage you, particularly the law students are here, to look at the University Faculty for Life website, because it has a lot of great resources on legal issues, and it's a good way to educate yourself about some of those issues. There's Brother Paul mentioned Father Kevin O'Rourke, who's very prominent on these issues, and there was an excellent article that we, University Faculty for Life, published, written by Mark Latkovic. That was a critique of O'Rourke's position that was published, and that's available on the internet, so I encourage you to take a look at that. I'm going to just briefly talk about some of the issues that I discussed in the article. One of the things that with the Schiavo litigation that's kind of interesting is the case received enormous public attention, but if you actually look at the legal doctrine that's involved there, the case is really insignificant, legally insignificant. I think that comes as a surprise to people. Some of the litigation was very dramatic, both in the state of Florida and in the federal courts, to try to get the decision overruled. And those cases are interesting, but don't really touch on a lot of the core issues that arise every day in this area. The case is legally insignificant, I think, in part because the law in this area developed through the mid-'70s through the early '90s in a way that was kind of below the surface in a lot of respects. Some of the cases got a lot of attention, the Karen and Quinlan case in '76 and some of the other cases, but most of them were cases that didn't really get a lot of broad public attention. And what they did was introduce a legal framework that's now pretty well settled, and that's the legal framework that was applied in this case. Basically was kind of working out of the principles set forth in the Browning case, which was a Florida Supreme Court case that probably only very few people in this room have ever heard of, that was decided in 1990. And the legal framework developed as basically state court. The Supreme Court justices don't deserve any real blame for this. I know a lot of times people in the pro-life movement, I think I've been guilty of this on a few occasions now and then, like to criticize Supreme Court justices. I think a lot of that is well deserved, and criticisms are valid. I think usually that some of that criticism can be misplaced, and certainly true with the Supreme Court. I think largely this is a broader cultural battle, and the problems in this area are not primarily a problem of activist federal judges. In this area, that's particularly true. It's less true in the area of abortion, but in this area, that's less true. Most of this is done by state courts. The U.S. Supreme Court has had a couple of decisions on the issue, but they have the Cruzan case and the assisted suicide cases in 1997. The Supreme Court really rejected the idea that there was a fundamental right to assisted suicide and basically left the issue to be worked out in state courts and in the broader culture. I think because of the experience in the area of abortion, the court was kind of anxious to deconstitutionalize the issue and put it in the hands of the state court. But the framework that's developed in the state courts is really bad. It's really terribly unjust, but it's kind of below the surface. The thing that was really significant about the Terri Schiavo case was that it got a lot of public attention because, as Bobby mentioned in the beginning, the withdrawal of treatment that went on here happens all the time. Happens every day in the United States. It's just that it's usually people don't object. And the really significant thing here was her family objected. They sought to save her life, and they deserve enormous credit for standing up for life, standing up for her in a situation that it would have been far easier, I'm sure, to not take a stand and get involved in a broad public controversy. And so the case is kind of legally insignificant, but because of their efforts, it became enormously significant, and we really owe them a lot for their efforts to try to highlight the injustice that went on in her case, but also that goes on throughout the country on a day-to-day basis. I think the problem in this area really is a broader cultural issue, and the way to fight that is the way that this network and foundation is trying to do, is to educate people about what's going on, to educate people about the terrible injustice that happens, to educate people about the flaws in the legal framework, and to try to get that changed through any measure. It's largely, as I said, cultural. One of the things that's the most encouraging thing about the pro-life movement is that increasing pro-life sentiment among young people. Kristen Hawkins' organization, I don't think you deserve all the credit for that, but deserve credit. You deserve a lot of credit for it because it's really important. And that's something that I think if you went back 20 or 30 years ago and looked at the kind of cultural drift at that time, and if you said, well, there'd be increasing pro-life sentiment among young people in 20 years, I think most people wouldn't have believed it. And it's because of the efforts to try to educate people about the sanctity of life, and a lot of it goes on without a lot of attention from the media. If we were fortunate, 4 of our children were in Washington on the March for Life this year. They came from, a couple of them were in Michigan, a couple of them down here, and they went there. And if you read pro-life materials, you realize it is they were just stunned. Some of them have been there several years, but just stunned at the number of young people there. And it gets almost no attention in the media, yet there's just this tremendously encouraging witness of young people to the pro-life cause and the sanctity of life that really gives us great hope for the future as we try to get this situation changed and to improve upon it. Let me talk. I know people have a lot of questions, and I don't want to spend a lot of time talking because most of the people here can ask me questions here on a day-to-day basis. We don't have these good folks here, and so I'd like to give you an opportunity to ask them questions. But I think that, let me talk about a couple of things that's a particular problem with the legal framework, the settled legal framework that was applied. There are a number of problems with it. In part, what it does, cases like Brown and some of these other cases, adopt this very extreme autonomy view. People make choices, and you have to respect those choices, even when they're making choices that traditionally wouldn't have been approved of, lethal choices in particular. But we can't really second-guess choices. People are entitled to make them, and so we can't assert interests, traditional interests like the important interest in life or public morality to prevent people from carrying out these lethal choices. And the problem of the autonomy view is kind of a broader one than here. It comes up in other contexts as well, but that's a particular problem. These cases, these state court cases, tend to accept it kind of uncritically. Probably the biggest problem with the cases is an issue that's already been touched on several times already, is that really what these cases do is represent a collapse of the sanctity of life ethic that's been an important part of our legal system for a long time. And they result in the adoption of a quality of life ethic. There was a comment made about the Bland case in England, which is a similar case to Schiavo, is that why that case is significant this commentator said it's significant. The Bland case is that it represents the complete collapse of the Western ethic on the sanctity of life. And it's a really significant case, this commentator said. I think one thing that's good about that comment is it illustrates what the stakes are. That these cases, and again, there's a whole number of them, really represent the collapse of the sanctity of life ethic. If you read the opinions, it's kind of shocking. They talk about the patients in these cases as just people that are barely alive. There's bare existence. They're not really human, or persistent vegetative state. Justice Stevens, one of my least favorite justices, talk about some of the opinions as they're not even alive. They're not even alive because they don't have the ability to interact with their surroundings. So the cases are full of things like that, mere corporeal existence. They lack any dignity. That's a common refrain in these cases like Browning and the Bouvier case from California. They lack any dignity. The fact that they're a human being and they're alive, according to this view, doesn't give them any dignity. Their dignity comes from something else. It comes from how much they can contribute, their ability to interact, their ability to engage in kind of the spiritual aspects of life or work would say. If they don't have those abilities, they're considered to lack dignity completely. In fact, the cases, Browning isn't quite as bad as the Bouvier case. They're basically, these people are better off dead. That it's an indignity to keep them alive, and they're better off dead. It's a life that's not worth living. They're better off dead. And that's really the principal problem in these cases, is they accept that idea. There's, in some ways, there's a bit about them that is hopeful. Is one of the things that the cases do, and this has been touched on already, is they obscure the fact that there are really lethal choices being made. See, we're not killing people. We're letting them die. They're terminally ill. And that's, I think, a good thing. It's a good sign because it shows kind of a conscience. Is there sort of people are reluctant to forthrightly approve acts of killing that take the lives of innocent human people. So they obscure it by saying, well, they're terminally ill. In these cases, these patients aren't terminally ill. Browning was not terminally ill. Terri Schindler was not suffering from a terminal illness. The problem was, sometimes people say, is the people in these conditions are biologically tenacious. They're not going to die soon enough from the perspective of people that would rather have them dead. So they're not terminally ill. They die from lack of food and water, not from the underlying condition. So the underlying condition is, and sometimes O'Rourke says, the underlying condition is inability to chew and swallow, to feed themselves. That's a condition that a lot of us had at various points in our life, and fortunately we're here through the care of others. But you see the kind of obscuring what's really going on. So it's important to really do the kind of education that's being done here and throughout the country by a lot of people in this room, to try to really let people know what it is that's going on, what's at stake, and to try to build a culture of life, to try to change that culture that now accepts largely this quality of life understanding, to try to get that turned around, to try to rebuild the culture of life. So, and it's encouraging to see that sentiment from young people. So I'll stop there and look forward to your questions.
Thank you, Professor Myers. And I just wanted to add to that. It's really what we're seeing at our organization by the calls we're getting, is a growing prejudice, a growing acceptance, if you will, of siloing people with cognitive disabilities into a category of being subhuman or non-persons, and because of that, accepting and rationalizing killing them. And that's what frightens us so much, is that more and more people seem to be accepting this notion that they aren't persons with traumatic brain injuries, they aren't persons with cognitive disabilities. They're in their own category, which is something much worse, something so bad that we should not keep them alive and make excuses to end their lives.